Welcome back to Topics and Decisions in Patent Law. I'm Joe Murphy.
I'm Reza Mollaaghababa.
I'm Reza Sadr.
Today we're diving into DDR Holdings patent infringement case against Priceline.com and Booking.com. This case gives us some guidance on the importance of the drafting of a provisional patent application. As you may recall, a provisional patent application establishes an early priority date for an invention. It provides a 12-month period during which the inventor can further develop the invention, seek funding, or test market potential before filing a non-provisional and/or international PCT application. While a provisional application does not require formal patent claims, it must include a detailed written description of the invention. And the benefit of filing a provisional patent application is that while it can establish a priority date, it does not count against the 20-year patent term. As I mentioned in our case today, we'll see the importance of drafting when relying on a provisional patent application. So the case itself arose out of the District of Delaware. So DDR Holdings sued Priceline.com and Booking.com, alleging infringement of 4 patents, including the one we'll be discussing in more detail today. That's the 7818399 patent, which we'll probably call the 399 patent. This patent covers a seamless e-commerce system designed to enhance affiliate marketing and online shopping experiences. So in response to the infringement action, Priceline petitioned for an inter-parties review of all 4 of the patents. The Patent Trial and Appeal Board invalidated 3 of the 4 patents. However, the 399 patent survived. An interesting point here, which we're going to get to in detail, but I'll start with a bit. The PTAB interpreted the term merchants broadly, stating that included both goods and services. And we'll see that this is important. After the IPR proceedings were over, the stay on the lawsuit, the district court lawsuit, was lifted and the case moved forward. The legal fight revolved around the interpretation of some key terms in the 399 patent. DDR argued that the merchants should include both goods and services, and Priceline.com counter-argued that merchants should only refer to goods. And we'll see why that is in a bit. The district court sided with Priceline.com, ruling that merchants only referred to goods and that the term commerce object also excluded services. This was adverse to DDR, as both parties had agreed to stipulate that under this interpretation, Priceline.com did not infringe the 399 patent. The district court then entered final judgment in favor of Priceline.com. DDR appealed to the U.S. Court of Appeals for the Federal Circuit, challenging the district court's claim construction ruling. So what makes the 399 patent so significant? This patent describes a seamless e-commerce system that embeds commerce links within host websites and generates dynamic product pages that match the look and feel of the host site. This innovation was important for affiliate marketing and online retail, allowing merchants to expand their reach while keeping users engaged. The outcome, which we'll see, highlights the challenges and importance of defining technology terms during drafting. So I think Reza Sadr is now going to give us a bit of a deep dive on the actual technology itself.
Yes, thank you, Joe. So let's look more closely at the patent and in particular at the claimed invention. In this slide, we have copied the claim, like one of the claims at issue, which actually was argued and discussed by the court. We have highlighted some terms that are important. This is not the whole text of the claim. We have summarized it for the parts that are important. So, and we're going to go into some details further down. But essentially, we are dealing with a method of an outsourced provider serving web pages. And in particular, what does the method say? Here, we are dealing with a case when a user activates or clicks on a link on that web page of the outsourced provider, and essentially the user is taken to another page which refers to the merchant and the product that is there. And upon further clicking or engagement, essentially the user goes to another web page which shows the details of the commerce object. And what's important here is that this web page, which is called composite web page, has elements that visually correspond to the source page. So what does that mean in reality? If we go to the next slide, here we are seeing how the invention works in action. And in particular, we are using the example of Priceline itself, which was accused of infringing. As you can see on the top left screenshot, this is the web page of the Priceline. But of course, it could be some other entities very similar, like, for example, Travelocity or Kayak. And here, when the user goes and searches for some specific items, in this case, I searched for hotels that are in New York and available within a time range, and Priceline comes up with some choices. In the next, when you click on the choice, I clicked on the New York Hilton in this case, the user is taken to another web page in which that specific merchant is presented. And if we click further on that merchant's link, we are taken to another web page, as you can see the third and the fourth screenshot, where the specifics of the merchant and the commerce object, in this case, the hotel rooms, are detailed, and the user here can explore and possibly select, or the user may go back to the original search and explore other choices. What's important here is that each of these web pages that are shown here, the so-called composite web pages, include that logo of Priceline on top left. And even at the end, I have shown that even the link address, the web address, has Priceline in it. Essentially, this whole thing is generated by Priceline, the so-called composite web page. And the idea is that the user is always aware that they are within the Priceline domain. So we should remember DDR, which is essentially a non-practicing entity that for which the business is monetizing on, for example, patents, asserted this against Priceline and other parties similar in the 2020s. But this is a familiar patent. We have actually discussed it in the previous video when we were talking about 101 and subject matter eligibility. There, it was asserted against other entities such as hotels.com. And that case went all the way to Federal Circuit as well. And there, hotels.com challenged the patent for subject matter eligibility, and their DDR prevailed. That was a seminal case in which a software invention was deemed patent eligible, subject matter eligible. But in this case, as Joe mentioned, Priceline approached it from a different angle and essentially asserted that the claim doesn't read on them because they're not providing goods, but they're providing services. And why that is important, we're going to get to. But before going there, Reza, I think you're going to tell us about the underlying laws of claim interpretation, which played a central role here.
Yes, thanks, Reza. So as Joe and Reza mentioned here, the issue of claim construction became an important issue, and in particular, in terms of what the meaning of the word merchant is. Generally, claim construction is a process by which the meaning of various terms in a claim are ascertained. And the standard for claim construction differs between examination and when the claim is being enforced in courts. During examination, as we know, it's basically the claim terms are given their so-called broadest reasonable interpretation, whereas for enforcement, the claim terms are interpreted according to their ordinary and customary meaning in general. The case of Phillips was a seminal case that discussed the issue of claim construction in detail. And generally speaking, the Phillips case indicated that the intrinsic evidence, the specification, the prosecution history are particularly important in figuring out what the meanings of the claim terms are. Although extrinsic evidence, such as dictionaries, can also be used, but the primary focus in claim construction is on intrinsic evidence, what the patent owner or patentee has provided. To this end, the patent owner or patentee can also define the terms according to what they like those terms to be, as long as those definitions are clear. Even though a definition may be different, provided by the patentee may be different from its customary meaning of that term, the patentee is given that ability to define the terms as they please. But I have to say that those definitions must be clear. So another issue that comes up in claim construction is what happens during the examination of the claims, because during examination, a patentee can make certain representations, for example, in order to distinguish the claims over prior art. And those representations can also have a bearing on what the meaning of the claims are. For example, if a claim term is distinguished from a particular way of construing it, which was done in the prior art, then the patentee cannot recapture that scope when the patent is enforced against third parties. To some degree, as I think we're going to discuss later, is a question of the notice requirement of a patent to allow third parties to really have some certainty in terms of what the claim terms mean and whether or not a particular product would infringe those claim terms. And this became clearly an important issue. Actually, it became a dispositive issue in this case. So I turn it back to Reza to continue with what happened in the case.
Yes, thank you, Reza. So in this next slide, let's look at what happened in the provisional and in going from provisional to the non-provisional. Here we are seeing like the front page of the provisional, which essentially was a brochure, which is a practice often we see especially when the applicant is in a hurry, they file, or for any other reason, they filed the brochure as the provisional. And we can see that while it's common, it also has its own pitfalls that one must be aware of. The provisional application refers to we can say, a hypothetical entity called NextChange. This is not a real company under the name NextChange, as I explored, and they're different. The NextChange here is the backbone of the invention, essentially the entity that creates and runs the invention. But the provisional explains that there are three parties, three players, besides the consumer or user. And there are the merchants, the hosts, and the NextChange itself. Now, aside from NextChange, let's focus on the two others. Hosts are essentially those operators of the so-called composite website or web pages that earlier we saw. And for example, in that case, it was Priceline. Then we are dealing with the merchants, which in that case was, for example, the hotel. And the hotel is the merchants that are producers of goods to be sold, as the first excerpt shows in the green box. And in the lowest red box, another part of the provisional application defines merchants as producers, manufacturers, and select distributors of products or services. That's explicitly mentioned. Now, if we go to the next slide, what happened in the non-provisional and eventually the patent? Here, the patent doesn't mention services. Here, merchants are defined as the producers, distributors, or resellers of the goods to be sold through the outsourced provider. No mention of services. So that's what Priceline was arguing, that we don't sell goods, we sell services. We refer to merchants that are selling services such as hotel rooms or air tickets or car rentals, stuff like that. And thus, the patent should not apply to us. And the Federal Circuit essentially agreed with Priceline. If we go to the next slide, in the ruling, the Federal Circuit says that the merchants, the term excludes services because the patent refers only to sellers of goods, not services. And that because the word services were omitted in the patent. And this deletion essentially means that there was a deliberate narrowing of the scope to goods only, especially when you contrast it with the provisional application, which mentioned services. And they even cited precedent, the case of MPHJ versus RICO, in which the court had ruled that a change from the provisional to the final patent significantly affects the claim interpretation, and thus they concluded that the services were excluded in this case. I should say that this patent by DDR was asserted in the 2010s against other entities, as I mentioned. So in this case, this new approach by Priceline was successful, unlike the attack which was made in 2014 by Hotels.com regarding subject matter eligibility. So I guess now we go to discussing some more details and nuances of the case.
One of the things that was interesting in this case was that the provisional application was incorporated by reference in the patent application that was filed. So the question arose, I think, also during oral arguments and in the briefs as well, that, well, if the incorporation by reference is considered as essentially the text of provisional was incorporated into the patent application, why couldn't the DDR rely on the fact that this was already by incorporation by reference in the patent application? And I thought that was an interesting discussion, that the court basically dismissed that and said, no, that's not sufficient. I guess that incorporation by reference was not sufficient. So I don't know what you guys think about that.
I think I'm not sure why they didn't allow that incorporation by reference, but I know during prosecution, when you run into these issues, you're trying to rely on a previous application for a limitation, and you specifically incorporated by reference. They often look for, or at least the examiners often look for, a specific citation, almost a direction to the particular thing you want to incorporate. So a blanket incorporation by reference sometimes isn't sufficient, even in front of an examiner. So I take it, the court's looking at it and saying, well, there's no particular direction here as to what you were incorporating, so therefore it's not going to be effective, and I think the really interesting thing, and Reza, you'd mentioned this about the brochure aspect of this, the provisional. Look, we've all been in a situation, you get a call on a Friday afternoon, and your client's got sales folks going out to some kind of convention, and they need to get something on file today because the convention's tomorrow. And so you do the best you can, and you file something like this, like the brochure or whatever it's going to be. And I think the interesting thing for me is that they didn't just take the provisional patent application word for word and incorporate it into the body of the new specification when they drafted up the utility. That's generally what I tend to do, and I would suggest that people do that for just this reason. I didn't realize, I was not aware that it had this detrimental of an effect, but just, a belt and suspenders way to approach it. Just make sure you have the entirety of the provisional incorporated into the actual words of what you're writing in the utility application.
Well, I think one thing that is interesting about that, if they had done that, then they would have two inconsistent definitions for merchant. So I wonder what would be the outcome in that situation. They would have one definition that is broader than the other, and both are actually clearly defined. I mean, they say merchant is, there's no ambiguity in terms of what they mean. So now you have two inconsistent definitions, and it would be interesting to think about what would happen in that case. I wonder whether the challenger or the defendant could argue in that situation that the term is indefinite because maybe inconsistent or at least different definitions are provided by the patentee.
I think.
Yes.
Yeah, go ahead, Reza. I'm sorry.
Sorry. Yeah, I think at least one important lesson in this case is beware of when you go from a provisional to non-provisional about things that may have changed. Usually, the good practice, of course, is you draft as complete as possible provisional. Our practice is, if we have enough time, essentially we draft a provisional which is just like a non-provisional, and we leave it. When we file the non-provisional, if needed, we make changes. But this way, you're certain that there's no such conflicts or contradictions between the two. But if you're under the gun, like the cases that Joe mentioned, you have to file a brochure, maybe a presentation, slide deck. Then you have to really look very closely at what you're doing and what is changed between what you already filed. I mean, if the text here wasn't suitable for inclusion in the probably text of the full application, but at least know what's changing. Of course, as they say, hindsight is always 20/20. You never know which part that changed will play as an essential part in the future of the patent, but you better be very careful and about what is changing.
One interesting thing about this is that in this case, they suffered because they had narrowed the definition. But I've seen situations where actually a broader definition would be detrimental because of prior art. So sometimes actually you may want a narrower definition to maintain the validity of the patent. And so it's yeah, as you said, I mean, you never know exactly what you will be facing. I've seen some practitioners define terms by defining it broadly and then say, for example, and then providing a series of narrower interpretations. And in those cases, I wonder, whether it would make sense to have dependent claims that recite the narrower interpretation so you as clearly delineate the scope of each claim.
Yeah, I agree with that. I think, and sometimes when you draft an application, you're going to have a term defined a couple different ways, just depending on the language you use and in a sentences you write, things like that. And I'd rather have I'm sure as a litigant, I'm not a litigator. I'm sure as a litigator, you'd rather have the ability to argue in court. No, we meant this definition as opposed to this other definition. And I think you'd rather be in a position where you're arguing about, prosecution history estoppel, what the examiner thought about the definition of the term, that kind of thing, because that gives you some wiggle room. Here they just dropped the word out, and so they didn't really have much to work with. It's a tough argument to make if you just literally drop the word out of the body of the utility application. And yeah, I mean, I think I like the way, Reza, that to approach it. If you have a claim 1 with a broad definition, a broad scope, claim 2 is slightly narrower, claim 3 is even more narrow. Each one of those shows that claim 1 is broader, and then you defined it more narrowly. So I think when we draft these things, you try to think, but again, you're thinking 5-10 years down the road. How what this is going to be in court. What's the art look like? You don't know. What's the competitor's product look like or services? You don't know. And you're trying to draft these things kind of in a vacuum, really. So you just give yourself as much room to maneuver as you possibly can.
Yeah, the issue of incorporation by reference, another thing that comes to mind is, as we mentioned, I mean, the notice function. That, that somebody who reads this and reads the prosecution history and tries to figure out what the patentee meant, the fact that they explicitly dropped, goods from the definition of merchants, maybe that's from that point of view, it makes sense to say that, look, such a person that's trying to figure out what the scope is would have put some emphasis on the fact that the patentee had done so.
Yeah. Of course, I have to mention another scenario that actually the credit goes to you, Reza. You mentioned what if the patentee in the non-provisional has included had included the provisional as an appendix, would that change the outcome? Because now it's explicitly in the text. Although I think then still the issue that you mentioned would be present, which is maybe contradicting definitions of the word merchant between the appendix and the text of the specification.
I have a feeling that if they had done that, I don't know, of course, for sure, they would have a little bit more leeway to argue that, look, we really are entitled to the broad definition. The other definition was meant in terms of, in some cases, in some situations, the merchants just provide services, but more generally, we are entitled to goods and services, and it's not really contradictory. It is simply providing examples of, but I don't know.
That's actually a very interesting point. A language we are very careful usually in our specification is use always sometimes annoying repetition of the terms like in some embodiments or this may. That's now would be so crucial for the argument that you mentioned. And I think that's a good practice.
Yeah, I can't tell you how many times I drop, in exemplary embodiments into the body of a specification just for that reason. You don't want to, I'm even, not to get off on a tangent, but why not? I have so many applications that I file that are called pharmaceutical composition and methods, probably 100, maybe more. I don't even like to put anything even in the title that might limit.
Yeah.
A court could look at it and say, hey, you call this a method of treating whatever, so you're limited to that, even though the claims may not be drawn to that. So that's why everything is called pharmaceutical composition and methods or whatever. So that's another way to look at it.
Very good. Actually, that brings us to the so-called profanities in patent prosecution and the applications, terms like using the word invention. You don't want to say invention is. And I'm looking at exactly the excerpt that I have in that slide. It's the patentee there says, merchants are the producers, distributors. How much things would change if they had said in some embodiments, merchants are, and that would give them more leeway for the argument.
But of course, what Joe said, and you said, Reza, as well, hindsight is always 2020. You're right. I mean, 10 years down the road, you can look back and you can figure out all the things that you should have done. But on the other hand, there are some good practices to follow in general, and that's what we generally trying to do to make sure that you don't fall in such traps.
So interesting case.
Yeah, this is a good one.
Never let our job to be boring.
It's a difficult job we have to try to divine the future and figure out how this is going to be enforced.
Yeah.
Again, what the competitors' products servers are going to look like, how the claims are going to be interpreted, and all that. So it's always a challenge, always interesting. So this was a great discussion. Thanks so much.
Thank you. Yeah.
Thank you.
Bye-bye.